minus the T. Niggas is talking.
All right, I wasn't even gonna make this video today, but I was reading law, because I'm trying to help some people I'm doing consultations for, and I always want to do research so I can know how to help people better. Even though August is going to be my last month for doing consultations, I want to give a shout out to the people who have called in, and I'm working with you, and I hope we can get all our stuff or all your stuff done as soon as possible. But I'm always available. So if you need access or you need consultation, you can hit my Instagram up. I'll put the link below. But as usual, I have to give something to the people who love law on this. And my fragrance of the day is Reflection Man. All right. So I want to go over this little statute in this court case to kind of let you know, kind of prove further what I was saying when I said that the courts are operating as arbitrations instead of what people think a general court is. Okay, this is a Wisconsin state statute, so it pretty much comports with all state statutes. Okay, so except as otherwise provided in this section, a complaint charging a person with an offense shall be issued only by a district attorney of the county where the crime. Now, remember what I'm saying right now. It should be only issued by the district attorney. Okay, so that means if you have a traffic ticket, well, they don't have a complaint. So how can they sue you? Okay, where the crime is alleged to have been committed, a complaint is issued when it is approved for filling by the district attorney. The approval shall be in the form of a written endorsement on the complaint or the electronic signature, which is basically a violation of the Fourth Amendment, of the district attorney as provided. I hope y'all understand what I just told you. I just told you how to beat all your court cases right there. All right. After a complaint has been issued, it shall be filed with a judge and either a warrant or summons. Okay, the complaint is actually a warrant. All right, or summons shall be issued, or the complaint shall be dismissed pursuant to, and they gave the rule. If a district attorney is unavailable or refuses or is unavailable to issue a complaint, a circuit court judge may permit the filing of the complaint. If the judge finds there is probable cause to believe that the person to be charged has committed an offense. Now, when you walk into court, you wonder why they ask you, are you the so-and-so? Well, what the judge is trying to do is he's trying to take over the case for the district attorney. So you're not getting due process. You're not getting due process at all. This is something huge that you need to bring up, because this is violation of due process rights. How can a judge determine the guilt of someone, right, when the person hasn't even had a hearing, okay, has committed the offense after concluding a hearing? See, they have to have a hearing first. But if you don't show up to court, what does the judge do? They issue a warrant. Well, how does the court issue a warrant when they don't know if they have jurisdiction or not? Okay, if the district attorney has refused to issue the complaint, he or she shall be informed of the hearing and may attend. The hearing shall be an ex parte without the right of cross-examination. If this is basically what they're doing to you in these traffic court cases, this is a violation of your rights. And by showing up, you're agreeing to this. Okay, if the alleged violator they gave certain statutes that probably don't conform, was a parent of guardian of a, okay, no, I'm not reading that one because that doesn't. So it gives me a court case. And this is basically proven to you, right, that the judge is operating separate from the court. You see what I'm saying? So you think you're going to court and the judge in the court is one. If you go watch my video where I said I did their presumed authority, I break this down, and this is Curvaceous versus Moroni, right? So I don't have the full case because I'm waiting for it to, get sent to me. So I don't have the full case yet. Yeah, they still haven't sent it to me. Oh, yes, they did. I'm going to read that later. But I'm just going to go over the short of it. Okay. In this case, right, this is Curvaceous versus Moroni, and it's a Wisconsin case, and it was submitted 1985, right? So this is an appeal from Outer Game County, right? So per this case on appeal, it basically says that it's stating that the respondent to Thomas Moroni. See, I don't know if the Moroni is a judge or what this is. So it doesn't really tell me. So I have to read the full case. But it actually tells you that I'm thinking Thomas Moroni is the judge. So I'm just going to go off of what I'm thinking. So it says Constance Curvaceous, or whatever her name is, appeals from the circuit judge's order refusing to permit the filing of a criminal complaint under section 968.02 stats. Respondent Thomas Moroni moves to dismiss the appeal, contending that the order is not appealable because we conclude the order is not appealable. What? We dismiss this appeal. As an appeal, of the right may be taken from a final judgment or a final order of the circuit court unless otherwise expressed by provided by law, meaning unless you contest jurisdiction. States the courts may grant leave to appeal from a judgment or an order not appealable as a right of, and it gives the citation. However, appeal is defined as a review of a judgment or an order of a circuit court order. Okay, so it says the order issued pursuant to 968.023 states which provides if a district attorney refuses or is unavailable to issue a complaint, a circuit judge may permit the filing of the complaint. If the judge finds there is probable cause to believe that the person to be charged has committed an offense after conducting a hearing. So it says after conducting a hearing. They have to have a hearing first to even move forward in a court case, which they call the I forgot the initial hearing. It's the shoot. I was just bringing this up. It's the arraignment. Took me long enough to figure it out. So at the arraignment, if you keep proceeding in the court case, the court will assume that it has plenary power. But if you read this case, watch, I'm going to go forward in this case. And this is how most cases are done, where they have a complaint from the district attorney, but it's like a warrant, but they really don't have the elements or the probable cause to go forward in a court case. But what they're doing is they're saying if to be charged with if the district attorney refused to issue a complaint, he or she shall be informed of the hearing and may attend. The hearing may be ex parte without cross-examination. Well, how can you don't you have a right to basically cross-examine whoever's alleging that you committed a crime? Isn't that a violation of due process? Of course it is. And the legislature allows this? This is crazy. Okay, so it says it's 968.2 bracketed 3 states the proceeding is not a court proceeding. It is not a court proceeding. Did you? It says it is not a court proceeding. The statute expressly provides that the proceeding is to be before a circuit judge, and there is an express distinction between a judge and a court. Read State X-Rail newspapers versus circuit court. It says, consequently, an order issued by a judge in section 968.023 proceeding is not a judgment or an order of the circuit court. The Supreme Court held that an order issued by a judge in a John Doe proceeding was not an order made by a court which could be appealed under the old appellate statute, State versus Washington. We reach the same conclusion and hold that a circuit judge's order is not appealable because it is not a judgment or order of the court. Boom. And you go back to my video where I said their presumed authority, where I told you that they are doing arbitrations in court. This case proves what I was saying, that the judge is separate from the court. And what the court does and what the judge does is two separate entities. When you go to the clerk's office, that is completely separate than what happens when you go into the judge's order, like the judge's courtroom or chambers. They're separate. So when a judge is acting, he has no judicial immunity. This is why that judicial immunity is bullshit. Judges only have immunity within their decision. That means that they have a right to pass a decision and not fear that they're going to be sued because of the decision they pass, as long as it conforms with state laws, the Constitution, and other guidelines. When a judge steps out of that, you can nail his ass or her ass to the fucking bench. So yeah, this basically sets up the distinction between the judge and the court, and it lets you know that you are in an arbitration. You are not in a court. If they're going to separate the judge from the court, then how can you be in a judicial proceeding? And how can it be a criminal proceeding? It's not. I'm out.